It takes a certain type of person to represent themselves at the United States Supreme Court. A lot of determination and a bit of madness. Out of all the people who I covered, Harrison Parker stands out as more on the crazy side. While appearing at the Supreme Court, fighting a contempt charge, he was committing mail fraud and running a church out of an apartment over a convenience store. To make sense of this guy's legal and business records, we need to divide up his life into eras: newspaper, business, litigation, and church, with some overlap. Harrison Parker was born in 1877 or 78. The economist Colston Warren is the only source I found mentioning Parker's early days as a newsboy in San Francisco. In 1899, his uncle and another newspaper editor in New Orleans killed each other in a duel started by a cartoon. Parker became a manager of the Chicago Tribune at 30. There's a record of him giving a talk in Toronto in 1907, when the Tribune was only the third most popular paper in the city. He then became president of the Chicago American, an afternoon newspaper, when he was 35. But within a few years, he left the newspaper, apparently in arguments over the First World War. Parker's time at the newspapers would be influential in his later scams and legal battles. In 1919, Harrison Parker founded the Cooperative Society of America, a business structured as a co-op, which latched on to the boom in mail-order businesses in Chicago, such as Sears and Montgomery Ward. The business appeared to be quickly successful, buying up several stores, banks, factories, and the Randolph Wells building in downtown Chicago, but it was always in legal battles. 2 years later, the business had a spectacular bankruptcy when a judge found that it had half of its claimed assets and much greater liabilities. Parker not only went missing, but a rumor claimed he had taken off with a chest with $2 million in Liberty bonds. That would be $36 million today. A later history of cooperatives would describe the problem as an intricate financial web which even the accountants were unable to untangle, which Parker admitted that he himself could not understand. When the bankruptcy terms were finalized in March 1922, a crowd of women who had invested rushed the courthouse and had to be held back by deputies. The bankruptcy allowed the business to continue operating, and when Colston Warren wrote his paper, there was some hope for it to continue, but would fail again that year, 1923. Warren's later writings would refer to Harrison Parker's spurious cooperative, and quote someone, "The National is no better than the Harrison Parker outfit. This was a notorious failure." Somehow, that was not the end of Parker's business era. In 1928, he would offer $110,000 from his old co-op to the North American Trust Company. This was likely worthless. He made other business decisions, including purchasing life insurance companies, which the other trustees came to oppose. In August of 1929, 2 months before the stock market crash, a violent quarrel broke out between Parker and 2 other trustees, throwing accusations of fraud. Reminder, this guy is in his 50s at this point. In 1931, Cook County found Parker guilty of embezzlement. Jail time concluded Parker's hopes at running a major business and shifted his interest towards the justice system. State's Attorney John Swanson proudly announced to the press, "Parker has been a financial racketeer in Chicago since 1912. There are thousands of victims of Parker in Cook County alone. His swindles in real estate were enormous." Of all Chicago's newspapers, only the Tribune published this blast, and Harrison Parker would claim the Tribune had libeled him for doing so. Before we move on to the next era, I found it interesting that Swanson gave a year, 1912, when the Cooperative Society wouldn't start until 1919. That's 7 years missing from the record where Parker must have been doing some unsound deals on the side while working at the Chicago American, and it makes it unlikely that his Cooperative Society was ever intended to be a sustainable business. I don't know if someone can dig up what was happening in those 7 years. It'd be interesting to see. Parker was victorious in Illinois State Supreme Court, which set him free in 1934. As best I can tell, it wasn't clear if Parker was embezzling money or just really bad at business. Parker's release revived the libel suit against the Tribune. In 1936, he self-published a book, How the Chicago Tribune Cheated and Defrauded the State of Illinois of $87 million in capital stock taxes. An article in Time magazine says that the Tribune was dodging taxes, but was following norms for business at the time. This strikes me as an interesting return of Parker's newspaper era, as he must have been aware of the Tribune's finances and knew it would embarrass them. Even in 1951, he would bring back his old accusations when Truman was trying to confirm a federal judge. Weymouth Kirkland, while representing the Tribune, delivered several insults in his opening statement, which would garner their own lawsuit, saying Harrison Parker was a contemptible falsifier, a contemptible blackmailer, and he has a diarrhea of the mouth. Parker's case against the Tribune came to an end in 1938, and he failed to convince the jury. After losing the Tribune cases, Harrison Parker continued his litigation era by going after the state attorneys. By this time, he had also founded what he called the Puritan Church, distributing long, rambling documents with religious and legal claims. Parker's Supreme Court case began in 1943, when Assistant State Attorney Jacob Schamberg called him a blackmailer, and Parker accused him of slander. By this time, Parker's letters and claims had gotten increasingly disturbing. Parker has stated under oath that the Puritan Church and Brotherhood of the Ancient Order of St. John have made plans to hang and murder numerous citizens and public officials. In 1945, a judge asked Parker if he had the original letters and could document a reason not to submit them. 2 days later, he filed the letters with an affidavit, sending them to the grand jury. Now, whether this was cooperating with the court in good faith or out of malicious compliance is not that clear, but both sides later agreed to calling these letters to the grand jury. Parker was charged with contempt, which would come with 90 days in jail. One of his supporting witnesses, Agnes Richardson, was a church member in LaGrange, Illinois. She was also charged with contempt. In 1947, Parker appealed the case to Illinois' state Supreme Court. This time, he was not as lucky. The gist of many wild, shocking, insulting, and scandalous charges contained in the exhibits is that all of the courts in Illinois, including the court in which his suit was then pending, are corrupt. In between the state Supreme Court case and the U.S. Supreme Court case, Parker began to place strange newspaper ads around the country to raise funds for his church. I'll explain this scam later on. Harrison Parker's case moved up to the United States Supreme Court in 1948. Though Parker represented himself, comments on the record indicate that he had counsel on standby and to help him at other stages. Parker believed that he could write to a grand jury and have them consider indicting someone who the state had overlooked. Justice Rutledge asked if he was a lawyer, and he admitted he was not. Parker also explained his comments about hanging judges, which he said would happen with a trial, and that was religious speech and not his own. William Wines, representing Illinois, gave the justice another look at these letters. Parker had insulted the Tribune editor's ancestors, saying that they were deloused and fumigated at Ellis Island, and undertook a number of crimes. He then went on to say the editor learned to steal while suckling milk at the breast of his ignorant mother. Wines also explained the correct procedure for bringing a matter to a grand jury. Losing at the court, Parker would serve the time in jail. As we end the litigation era, I think it's an open question whether the court ruled on a constitutional basis. It's a bit silly to think that submitting the documents is contempt, and the dissent says as much. If the contents were different, I doubt that the state and the justices would be so opposed. In between the state and United States Supreme Court cases, Harrison Parker submitted what was called a map puzzle, to several newspapers. Responses to the ad went to Agnes Richardson's address in downtown LaGrange, Illinois. At the time, it was above a drugstore. Here's what it looks like today. The map puzzle received 688,000 responses and raised $250,000, about $3 million today. By 1949, accusations were made against Parker, his sister Anita, and her husband, Vigo Bird. The letter writers had been asked to send more money to improve their chances, and it was clear that there was no congregation, no built church, and no winner. Why did this scam involve a map puzzle? Parker, with his newspaper experience, likely knew that a mail-in lottery would be illegal to conduct and to print in the paper. By adding a simple puzzle, the Postmaster General would later concede that this was a game of skill. It would also have so many correct solutions that no one letter writer could expect to be the sole winner. This type of puzzle contest was so popular at the time that this Postmaster General successfully challenged it in the Supreme Court in 1948's Donaldson v. Reed magazine. Would Parker face justice for this new scheme? Charges were kept on hold until he could finish his previous sentence. Meanwhile, Parker's relatives were getting their turn in court. The brother-in-law, Viggo Bird, came from Denmark to Connecticut in 1913. He had worked as a utility and railroad manager until he used railroad bonds to back his personal loans. Bird was convicted in 1939, spent 5 years in prison for embezzlement, then went to Canada. Shortly before the map puzzle scheme, he had sought but failed to get a pardon in Connecticut. Mrs. Anita Bird insisted that the money was in the bank. By September, the Bird family assets in Connecticut were seized and sold. In December 1949, Harrison Parker appeared before a judge who faced such ridiculous statements about his personal life and his membership in the Catholic Church that he quickly directed the case to another judge. In 1956, 9 years after the map puzzle, only about a quarter of the funds were recovered. The postmaster explained how this fraud could be allowed, calling it a game of skill, maintaining a church-building committee, and making some concessions allowed the scam to evade justice. In the meantime, Parker had moved from the Chicago area to the Norwood Building in Washington, D.C. In 1958, he attempted to reach the Supreme Court again, but his case was not accepted. Possibly it was this case which was dismissed from the appellate court. During the 1960 presidential election, Parker became obsessed with using his church to denounce JFK. In September, he was one of 4 names given by the Democratic Party as anti-Catholic extremists. Some of the documents from Parker's church, including this letterhead, are preserved at the JFK Presidential Library. By now, the Catholic Church, the Supreme Court, and the Chicago Tribune were part of one grand conspiracy in his mind. He and the church filed a lawsuit in November 1960, but by 1961 the appeal was abandoned. I suspect this might be due to Parker's advanced age or death, as he would be in his 80s. I suspect for almost everyone this is the first time that they're hearing about Harrison Parker, so it's difficult to describe him having a legacy. For some reason, his case against Illinois tends to be a go-to for historians describing self-representation at the court. For example, this article from 2013, when the court ended the practice. Now, the photo that I've been showing you is an actual physical photo that I ordered. This is the only one I was able to find. It has Harrison Parker, his wife, Edith, and over here is his sister, Anita Bird. And on the caption on the back, it says, Supreme Court aides said that the last time they could remember a man arguing his own case before the High Tribunal was in 1924. There is a previous case, Griffin v. Griffin, which doesn't count as Mr. Griffin was a disbarred lawyer. And in Blumenthal v. United States, which I'll cover soon, most defendants had counsel of their own. Before 1945, there is less documentation about pro se litigation. I found one eminent domain case in 1924, Campbell v. United States, but he appears to be a former county prosecutor. In 1925, Harry Stills challenged the United States over his combustion engine patents. And in a 1926 case, Morse v. United States, Morse had been dismissed from the federal service, but I don't know if he had been a lawyer before. If you want to hear more episodes about people representing themselves at the Supreme Court, please like and subscribe. United States Supreme Court rules and practices have changed since these cases. This was a podcast episode, not legal advice.